Jeremy Hogan confirms plans for the future Ripple XRP when they beat section. In a tweet on Saturday, Brad Garlinghouse, the CEO of Ripple, said that the U.S. Securities and Exchange Commission has forgotten about its responsibilities to consumers even though it is still enforcing rules. The price of XRP as of today is $0.35, and the trading volume for the past 24 hours is $136 billion. We're updating the US dollar price of XRP in real time. XRP is down 30% in the last day and a half. World Crypto Finance. If you liked this video, don't forget to like it and sign up for the channel. Do you agree with the analysts about XRP? Write your answers in the comments, and I'll give you 500 XRP. At the end of the week, XRP coins will be sent to a random subscriber. Check out the comments for how to do something. You just have to write the word XRP. See the whole video to like and subscribe. In the past few days, the Relative Strength Index, RSI, has not been clear. Last week, the RSI held a value of 50, which is a neutral value, as support. However, this level has not been passed recently. So, there could be some ups and downs over the weekend. Also, the Awesome Oscillator, AO, was below zero, but it hasn't yet shown a strong bearish impulse. The /D line had a resistance zone right above it, which was shown by two white lines with dots. If a /D can get past this area, it will show that demand for the XRP rally is strong. The Directional Movement Index, DMI, showed that there wasn't a strong trend because it was at level 20, just above the 20 mark, and the color was yellow. Technically, this meant that there was a downward trend, but it also meant that there hadn't been a big trend in the last few days. In the next day or two, the 35 to 36 cents range for Dash will be important to protect the bulls. If a lower low forms below this area, it will mean that sellers are getting stronger. On the shorter time frames, momentum indicators were not clear. Bitcoin could also have a big effect on where XRP goes in the near future. Eleanor Terrott, a reporter for Fox Business, talked about how strange it was that Jay Clayton and William Hinman were in a position where they accidentally helped Ripple. Terra sent the tweet to former head of the Securities and Exchange Commission, SEC, Jay Clayton, who started the lawsuit against Ripple Labs, Brad Garlinghouse, and Chris Larson by saying that XRP is a security, is now supporting Ripple in a roundabout way. He does this while working at Electric Capital, which is part of the Crypto Council for Innovation. Clayton joined the Electric Capital as a consultant in August of this year. Clayton worked for CCI, which was one of the companies that decided to ask Ripple Labs for help. Jay Clayton and Bill Hinman, who are both members of the Crypto_Council, are now supporting Ripple by being connected to Electric Capital into the 16Z. This is irony at its finest. In this way, CCI represents the views of industry veterans. William Hinman, a former SEC director who gave a speech in 2018 titled Calling Ethereum an Asset Unrelated to Securities, joined the board of Andreessen Horowitz. Both this company and the Electric Capital are members of the Crypto Council. This organization was one of the four that asked the fintech company Ripple for help in the last 24 hours. The other three were the Coinbase Exchange, the venture capital firm Bell Hill Capital, and the founder of Crypto Law, John E. Deaton. James K. Phelan tweeted about this. Hashtags or community hashtags SEC versus hashtag Ripple hashtag XRP. Justice of the PeaceNet Byrne agreed to the SEC's request to change two drafts of Hinman's June 2018 speech, which talked about decisions that the SEC had yet to make. In an application from October 21, 2022, the SEC made two suggestions for changes it wants to make to the documents. The SEC says that, in accordance with the court order from July 12, 2022, the two proposed changes talk about the agency's unresolved problems. The Securities and Exchange Commission asks that the proposed changes to two drafts of Director Bill Hinman's June 2018 speech, which talk about upcoming decisions of the Commission, be looked at more closely. After looking at the proposed changes, the Securities and Exchange Commission said in a statement that Magistrate Ned Byrne agreed to the SEC's request to change 2 drafts of Hinman's speech in 2018. So, the Justice of the Peace Ned Byrne ruled that the plaintiff's request to make the above changes was granted. Hinman used to be the SEC's Director of Corporate Finance when the board was led by Jay Clayton. In June 2018, he gave a controversial speech in which he said that Ethereum was unsafe because the cryptocurrency registry had become decentralized over time. This made him well known in the cryptocurrency industry. After the SEC said that Ripple was selling securities that weren't registered, the blockchain company asked the agency for drafts of Hinman's controversial speech in 2018. But the SEC was not ready to give up, and it took a lot of steps to stop Ripple from taking the drafts. After fighting 6 different court orders for 18 months, the SEC finally gave Ripple the documents, but internal emails and drafts of Hinman's speech are still secret. The CEO of Ripple, Brad Garland House, said about the event, "The SEC wants you to think that it cares about the school. See how clear and open things are. Don't agree with them. When you find out the truth at the end of March 2023, you will be more and more shocked by how shameful they were here." Sounds like a likely end date for the lawsuit between Ripple and the U.S. Securities and Exchange Commission, which will please people who like to believe in conspiracies. At the same time, the release of BISO 200-2 was moved from November 2022 to March 2023. James K. sharing an updated schedule of what will happen in the Ripple trial, Feeling said that even though some things have changed, he still believes that the Tour's district judge will decide on both the petitions of experts and the petitions for a simplified procedure at the same time and no later than March 31, 2023. I still think that the district judge Torres will decide both the expert reasons and the summary judgment reasons at the same time on or before March 31, 2023. Jeremy Hogan, an American lawyer and partner at Hogan who has been following the case, backs James K. Judge Torres tweeted that he had a feeling about when he might decide on expert petitions and summary judgments, and he said, March 31, 2023. So, there you have it, March 31, 2023. This means that the case is likely to be settled in the next 4 months, which is a very optimistic prediction. At the DC FinTech Week conference, Brad Garland House, the CEO of Ripple, said that the SEC lawsuit against Ripple will be over in the first half of 2023. Garland House says that it's possible that the lawsuit could be settled in the next 3 to 4 months. But he doesn't say that it won't take longer. Garland House said that Ripple might think about making a deal with the SEC, but he stressed that XRP must first be seen as a paper with no value. In September, both the SEC and Ripple filed motions for summary judgment. They asked District Judge Annalisa Torres to make a decision based on the arguments in the documents that went with the motions. After that, both Ripple and the SEC responded to the other's motion for a summary judgment with their own. According to an earlier plan for the case, responses to the motions for summary judgment were supposed to be sent in by November 15th, but they were put off until November 30th. When all the briefings should be done and Judge Torres should make a final decision. Members of the XRP community have noticed that the launch of ISO 200-2 and the end of the trial now happen at the same time. This is because Swift announced that it would move the switch to ISO 200-2 from November 2022 to March 2023. At the request of the international financial community, the decision to delay Swift was made in connection with the change in the date of the Eurosystem's migration to ISO 200-2 in the area of cross-border payments and reporting CBPR+. Today, the nonprofit Blockchain Association asked for permission to write a summary of the lawsuit between the Securities and Exchange Commission and Ripple Labs. This will give more information about how the agency's arguments in the case may affect the crypto industry as a whole. If it is approved, the group's arguments will be taken into account when the court makes a summary judgment based on the amicus curiae note that was sent along with it. These kinds of summaries can put the facts in a new light and help us understand them better, but they can't add any new facts or evidence to the case. The U.S. District Court for the Southern District of New York recently reached the summary trial stage of a case. Both sides argued that the trial wasn't necessary because the facts weren't in dispute. Instead, they asked the judge to decide the case based on the facts that had already been presented. The Blockchain Association, an advocacy group based in Washington, D.C., wants to explain what the ruling could mean for the crypto industry as a whole. It wouldn't be too much of an exaggeration to say that the decision in this case, if it isn't based on specific facts and legal issues that are minimally needed to solve this case, can have very bad effects on the trillion-dollar industry. Given that blockchain technology has a lot of uses, this could hurt a big part of the American economy in the future, the Blockchain Association said in a statement supporting the report. The proposed review includes examples from the industry that show how tokens are used outside of what is considered an investment contract. The SEC sued Ripple for the first time in 2020, saying that it had not registered its XRP token as a security. Since then, during the trial, the SEC has said that XRP is a security both when it was first issued and when it was sold on secondary markets. The SEC's harsh view that a token that was sold as part of an investment contract cannot be separated from that contract even if any legal rights between the issuer and the original buyer are not transferred along with the token will almost wipe out an entire industry. The amicus report says that the summary tries to give an idea of which parts of the industry might be affected by what the report calls poorly defined rules for using tokens. He also doesn't agree with the SEC's history of making public statements that are inconsistent, incomplete, and hard to understand. The SEC's idea that market participants can just follow securities laws isn't true, because securities laws don't take into account how an asset that could have been issued as a security can exist when it's no longer tied to any kind of investment contract. This is important when trying to apply the Howey test. The Blockchain Association's request is one of the 10, even though many other groups wanted to present their amicus arguments. U.S. District Court Judge Annalisa Torres agreed to let Investor Choice Advocates Network and Spend the Bits file amicus curiae briefs in support of the Ripple blockchain company, which has been in a tough fight with the U.S. Securities and Exchange Commission for almost 2 years. What do you think XRP will be like in 2023? Write what you think will happen in the comments. Thank you for making it to the end of this video. Please remember to like it and subscribe to the channel so you don't miss any new videos. Also, don't forget to enter our contest in the XRP comments to get 500 XRP added to your account.